Hello and welcome everyone. I hope this message finds you fit and fine. We are in video number 50 of our Lakshmikant series Kanthas, and today we need to talk about State Legislature 2. Means we have discussed other half in the previous video. I want you to recollect what we discussed in case of Union Legislature. Let's start with presiding officers. In case of Lok Sabha, I hope you remember Speaker and Deputy Speaker. Same is the position in case of State Legislative Assembly. If a State Legislature is having two houses, means bicameral legislature, then the same format. Like in case of Rajya Sabha, we have Chairman and Deputy Chairman. Similarly, we have in case of State Legislative Council, Chairman and Deputy Chairman. If these two presiding officers of the both houses are absent, who is going to preside the house? We have a panel in both houses. Right? In case of Union Legislature, in case of Lok Sabha, we have panel of chairperson. In case of Rajya Sabha, we have panel of vice chairperson. Same is the format in case of State Legislature, right? Now, Speaker of the Assembly. A Speaker is appointed from among the members, I would say elected from among the members of the State Legislative Assembly. He vacates his office in which of the following cases? Number one, ceases to be member of Assembly. If you became Speaker, but now you have resigned, or you got disqualified as member, it means now you will not be considered as Speaker anymore. Resigns, and whom is going to resign? Resignation will be given to Deputy Speaker. You can easily remember it. A Speaker is going to give resignation to Deputy Speaker. Deputy Speaker is going to give resignation to Speaker. Okay, and same is the format in case of Legislative Council. Chairman is going to give resignation to Deputy Chairman, and Deputy Chairman is going to give resignation to Chairman. Easy, right? If he is removed by resolution, and which majority is needed? Effective majority. All the then members of the assembly, means vacant seats are not going to be included. Same is the case of Lok Sabha, Rajya Sabha. 14 days prior notice need to be given if you want to remove this speaker via this resolution, right? Now, powers and duties, same format. What is the power? Maintain order and decorum in the assembly. Final interpreter of constitution within the house, rules of procedures and conduct, legislative precedents within the assembly. So all of these functions are taken care of by a speaker. He adjourns the assembly or suspends the meeting in the absence of quorum. It means the minimum number of members which are required to conduct the proceeding, that is 1/10. For example, if there are 100 members in the house, that is the total strength, then you need at least 10 members to conduct the proceeding. If even these number of MLAs, or in case of Legislative Council MLCs, are not present, then presiding officer will say, I am not going to conduct the meeting. Okay? He does not vote in the first instance because you are the presiding officer. You need to act neutral. But in case of tie, you can vote. That vote is going to be called as casting vote. Okay? He can allow a secret sitting. It means members other than the members of the house are not going to be allowed. Right? It can happen, right? Media is not going to be allowed. So secret sitting can be allowed by presiding officer. This power is with presiding officer. He decides whether a money bill or not. Means Council of Minister of State is going to present a bill before Speaker of Legislative Assembly. Sir, please declare this as money bill. And he will say, okay, I am declaring it. So only presiding officer, or you can say Speaker of Legislative Assembly, is having power to declare a bill as money bill. And his decision is final. He decides the question of disqualification in case of anti-defection. You are a member, where it is found that you have defected to other party. Means under 10th schedule, you need to be disqualified. Who is going to take the final call? Presiding officer of the house. In case of Legislative Assembly, a speaker is going to take the decision. Right? Now tell me, what if you are a MLA, but you have flouted some rule which is mentioned in Representation of People Act, or you have flouted some rule which is mentioned in our constitution. For example, you took citizenship of other country. Now, who is going to remove you? In that case, governor of the state is going to remove you on the recommendation of Election Commission. I simply told you there are 3 pillars of removal, disqualification. In one pillar only, that is anti-defection law, presiding officer of the house holds the power. In other 2, governor, and at the level of union, president, on the recommendation of Election Commission. And my friends, if question is asked by UPSC whether in these 2 cases recommendation of Election Commission is mandatory or not, it is mandatory. Whether such recommendation and such decision by president or governor in case of state can be considered under judicial review? Tell me, answer is true or false? Answer is true. For example, case of 21 Aam Aadmi Party MLAs in Delhi. So they were declared disqualified by President himself because it's a UT, not a complete state. And Delhi High Court put a stay there, right? It can be under judicial review. So it means you have to keep your eyes and ears open. What is happening? And just grab the provision part of polity, which is in news, right? He appoints the chairman of the committees of the assembly and supervises the functioning. 3 committees, please remember, himself the chairman. Business advisory committee, same in case of Lok Sabha speaker. Rules committee and general purpose committee. It means just remember what we discussed in Lok Sabha and it can be replicated here also. He can allow secret sitting, as we discussed. Deputy speaker of the assembly. Deputy speaker, another position. This is also elected one. It's not like speaker of legislative assembly has actually given this position to someone. It's not a nominated position. Please remember that. Usually remains in office during the life of the assembly, vacates in these 3 conditions, same. Means ceases to be a member, resigns to speaker, or removed by resolution. All the then members. It means same majority. 14 days notice. So CRR 14. Please remember, when it comes to presiding officers, whether Lok Sabha, whether in this state legislature, whether speaker, deputy speaker, chairman or deputy chairman, this 4 conditions you need to remember. That's it. Deputy speaker performs duties of the speaker's office if speaker is not in the house. Also acts as speaker when later is absent. Speaker nominates from among the members a panel of chairperson. That's a separate panel, right? For the purpose, if both are not present, then someone from the panel is going to preside, right? One among them. And same power as the speaker is going to be held by the person who is presiding the house. Now, chairman of the council means chairman vacates his office in any of the 3 cases. Means we are talking about legislative council. Okay, Vidhan Parishad. Ceases, resigns, removed by the resolution by a majority of all the then members of the council. Such a resolution can be moved 14 days. Presiding officer powers and functions as the same as case of legislative assembly. It means you have to conduct the proceedings of the house as per the rules and process. You are going to decide which agendas are going to be taken first, which later, which person is going to given preference for actually speaking out. However, the speaker has one special power, that is money bill. Only speaker can decide whether a bill is money bill, not chairman. They are charged on consulate fund, means expenditure on these houses is charged on consulate fund of India. It means you are not going to put this to vote or to put this to discussion and vote how much you need to give this year. Deputy chairman, same. Ceases, resigns, removed, 14 days notice. Performs duties of the chairman's office if chairman is absent, means vacant. Acts as chairman when absent. Tell me if there is any difference between these words vacant and absent. Yeah, there is. When I say vacant, it means no one is representing that particular seat. But when I say absent, absent means that person is not there, but someone is there on that position. It may be possible that person is ill, that person is not present due to some jobs elsewhere, right? This is the difference between absent and vacant, right? In vacant case, you have to appoint, elect or nominate some other person there. But in case of absent, no, that person, someone is representing that position, right? Chairman nominates from amongst the members a panel of vice chairman. Any one of them can preside. Now, sessions of state legislature. First of all, you have to call the session. Calling the session is called summoning. Who summons the house? Governor, on the advice of Council of Ministers. And what is going to be the maximum gap? Maximum gap can be 6 months between 2 sessions of state legislature. In case of adjournment, adjournment का मतलब है that within the proceeding, means consider house has started and within this time house is ending here, this is ending, this is starting. Within that you can adjourn the house for 2 days, 3 days. Who can decide that? This can be decided by presiding officer, not by the governor. Please remember that. Adjournment signed by, it means now we are at this stage and now presiding officer saying that we have completed the agenda of this session. Now, sir, we are doing adjournment signed by. It means I'm I'm saying that yes, these MLAs can go back. We are not holding session, and I'm not declaring the time when the session is going to be held again. And now this is an indication to the governor, and governor can actually say, okay, I'm proroguing the session. Means session itself is going to end now. Now dissolution. Legislative Council is a permanent house, right? You cannot dissolve Legislative Council. Same is the case of Rajya Sabha, right? Only Legislative Assembly can be dissolved, okay? Unlike the prorogation, a dissolution ends the very life of existing, means Legislative Assembly. That can be asked as a question. Why? Because when I say prorogation, it means governor is saying, "ठीक है, job is done. I'm declaring proroguing this session. Session is ending. Now I'm going to call another session." But when I say dissolve, it means the Legislative Assembly itself is getting dissolved. Now we need fresh elections. Okay, this is the difference between dissolving and prorogation. Position with respect to lapsing the bill. You remember the trick which we discussed in lapsing of the bills video in case of Lok Sabha? Same trick you need to remember. The trick was, consider legislature which is say bicameral. Okay, a bill is introduced in Legislative Assembly, and now that Legislative Assembly got dissolved. So bill will also dissolve, or you can say lapse. You are going to use the word lapse with the bill. Why? Consider that Legislative Assembly is getting dissolved. So Legislative Assembly has some shrap or sin over it. Okay. So now consider second case. Legislative Assembly passed the bill, and now it is in Legislative Council. And now Legislative Assembly dissolved. What is going to happen? Bill is going to lapse. Why? Because this bill has already introduced in Legislative Assembly, and that Legislative Assembly is having some shrap or sin. Okay, and protection can only be given when this bill touches Honorable Governor. That's a trick. Okay. So consider a third case. The bill is introduced in Legislative Assembly, also passed from Legislative Council, and now this bill is before Governor. And at this moment, Legislative Assembly dissolves. Now tell me, the bill will lapse or not? Bill is not going to lapse. Now this bill has touched Honorable Governor. That is third case. Fourth case. Consider a bill was introduced in Legislative Council. It has not been touched or introduced in Legislative Assembly, and Legislative Assembly dissolves. What is going to happen with the bill? Bill will remain. It is not going to lapse. Next case. Bill introduced in Legislative Assembly, passed from Legislative Council, presented before Governor, but Governor returns the bill for reconsideration in Legislative Assembly, and now Legislative Assembly dissolves. What is going to happen with the bill? Bill is not going to lapse. Why? Because it has once touched Honorable Governor. The security has, the boost has been given. Okay, so this is the easy way to actually remember this trick. Okay, and you are not going to mark any question wrong. Prorogation, I told you, who is going to do that? Governor is going to do that on the advice of Council of Ministers. If UPSC make a statement that Governor can adjourn the House, proceedings of the House, tell me the statement would be true or false. Some of you might be thinking, he is Governor. He may actually do this also. No, that's not possible. Because adjournment and adjournment sanda can be done by presiding officer only, not Governor. Governor start the proceeding and Governor start the session and end the session. Within that, function will be taken care of by presiding officer. Within the next few days, means after adjournment signed by, within the next few days, prorogation is declared by Governor. However, Governor can also prorogue the House within session. Means even when adjournment signed is not issued by presiding officer, then also Governor can prorogue the session. But prorogue, end the session. Unlike adjournment, prorogation terminates the session of the House. Terminates session. Now we are going to have fresh session. When I say quorum, I told you minimum number of members which are required for continuing the House proceedings, that is 1/10. If there is no quorum, it means what is going to happen? Presiding officer can actually adjourn the session or suspend that particular session. That you have to come again with a due strength. When it comes to voting in the House, all the matters at any sitting of the either House, they are done by simple majority, means majority of members who are present and voting. Is specifically in some instances we have other, you can say, other majorities which we call, say, spatial majority, effective majority. Only a few matters which specifically mentioned in Constitution, removal of the Speaker of the Assembly, Chairman removal and so on, spatial majority, you can say effective majority in this case, not ordinary majority is used. The presiding officer, Speaker of the House or Chairman in case does not vote in first instance, you all know that whoever is going to preside the House, that's a rule. That person cannot vote in first instance. First voting should happen, matter should be decided. If there is a case of tie, then only presiding officer can vote. We call it casting vote, right? Rights of ministers and advocate general. Both have this common function. Whichever house member you are, in case of minister and advocate general, it means you can say topmost legal officer of state government, they can actually present in any of the house. They can take part. They can speak also if they are asked to speak, but they cannot vote. Means minister can vote only in that house in which minister is member, and advocate general obviously cannot vote. So minister and advocate general of the state have right to speak and take part in the proceedings of the house. Minister can participate in the proceedings of the house which he is not a member. Consider a minister who is not a member of either house. It means that minister can continue in such position for 6 months. Before that, that minister has to be part of any house. Not a member of either house can participate in the proceedings of both the houses. Same case, right? So please remember, either house and speak, but vote only where you are member. Clear? Legislative procedure of state legislature means how laws are made in state legislature. Consider ordinary bill. So ordinary bill can originate in either house, whether legislative assembly or legislative council. Such a bill can be introduced either by a minister or other member. Please remember, this particular provision is applicable only in case of ordinary bill, not in case of money bill. Because in case of money bill, it can only be introduced by a minister. Why? Because money bill talks about matters related to expenditure from Consulate Fund of India, or in case of state, Consulate Fund of State, right? Increasing taxes, decreasing taxes, such kind of functions are there. Although in case of taxes, a lot of powers by state has been shifted to GST Council now. But the point is, related to expenditure revenue, who is going to take such reasons? Government, right? And that is why minister actually introduced this money bill. Okay, that is why it is called public bill. Okay, government bill you can say. After the bill is passed by originating house, it is transmitted to second house. A bill is deemed to have been passed by the state legislature only when both the houses have agreed to or with or without amendments. Same case. In case of unicameral legislature, you just need to introduce this bill in legislative assembly. When it is passed, it is presented before governor and governor signs, it becomes an act, right? So it means bill presented in state legislative assembly, then this, when it is passed from here, state legislative council, when it is passed from here before governor, governor signs and it becomes an act. If state legislative council is not there, then this bill is going to be presented in state legislative assembly and directly it is going to be presented before governor. Okay. Now bill in second house. Consider a bill is cleared by legislative assembly and presented before legislative council. Now there is an important aspect, question can be asked. Sometimes UPSC actually try to compare within a statement this particular part of state legislative council with Raj Sabha, and it is going to be quite simple for you. We are going to discuss each and every provision. When a bill is passed by the legislative assembly and transmitted to the legislative council, the letter has 4 alternatives. 1, may pass the bill as it is, okay, without any amendment. May pass the bill with amendment, saying that we want these changes. In this case, this bill needs to be presented again, return to legislative assembly. Okay. May reject the bill altogether, that we are not agreeing with that, or may not do anything. So these are the 4 alternatives with legislative council. But what impact it is going to have on the bill? If the legislative assembly rejects the amendments suggested by the council, for example, this second point was used by legislative council, that we want these changes. Now legislative assembly is saying, oh, you are saying these changes. Okay, we are accepting it. It means if we are accepting, now it is going to present it before governor and governor signs and it becomes an act. But it may be possible that Legislative Assembly says we are not accepting, we are rejecting the amendment suggested by you. Council does not take any action for 3 months. Now they are presented this bill again to the council that we are rejecting, and now council is, say, in first instance, council actually took this bill on hold for 3 months. Okay, in first instance, council can actually hold the bill only for 3 months. Okay, and then this bill is presented back to the Legislative Assembly. Okay, so now you should remember, in first instance, Legislative Council can hold the bill only for 3 months, and in the second instance, with amendments or without amendments, when Legislative Assembly is giving back the bill to the Legislative Council, this time Legislative Council can actually hold the bill just for 1 month. It means maximum delay period can be 4 months, not more than that. I hope you are able to understand. Legislative Council has less status when it comes to legislative power in comparison to Rajya Sabha. In case of ordinary bills, we discussed, if there is a case of deadlock, it means legislative, for example, Rajya Sabha is not agreeing with the amendments proposed by Lok Sabha, or Lok Sabha means there's no consensus between two houses. In that case, joint sitting can happen. But in case of state legislature, no case of joint sitting is mentioned. Please remember it, there was question asked on this. So in case of state legislature, Legislative Assembly has more say. The Assembly may pass the bill again and transmit the same to the Council. If the Council rejects the bill again or pass the bill with amendment not acceptable to the Assembly, does not pass the bill within 1 month, as I told you, then the bill is deemed to have been passed by both the houses in the form which it was passed by the Assembly for the second time. So it simply says, whatever Legislative Council can do is to stall the bill for 4 months at max. That's it. Legislative Assembly has more say in ordinary bill as well as money bill. Let's attempt this question so that it can settle in your mind a better. The Constitution does not provide for the mechanism of joint sitting of both the houses in state to resolve the disagreement between the two houses over a bill. You have to say the statement is correct or not. Okay, the statement is correct. I have just told you this. Council can detain or delay the bill for a period of 4 months, 3 months first instance, 1 month second instance. I have just told you it is correct. The Council has been given lesser significance, position, authority than Rajya Sabha at the center. This is what we discussed. Correct? It means answer is all of the above. Right? I hope it is clear now. Now assent to the Governor. Consider the bill is passed, okay, from Legislative Assembly and Legislative Council. Now before Governor can give assent to the bill, then it can become an act. Governor may withhold the bill, then it will not become an act. May return the bill for reconsideration, but this return can happen once, and when it is sent back to the Governor that we are not agreeing with that or we have accepted some of your suggestions, then Governor must accept it. Same is the case with President. May reserve the bill for reconsideration of, you can say, President. So it means assent, withhold, return and reserve. This part we discussed when we were comparing the powers between President and Governor also, right? If Governor gives assent to the bill becomes an act. Withhold, the bill ends. Return the bill with or without amendment, presented to the Governor again, Governor must give his assent. Means for once this can be returned. Thus the Governor enjoys suspensive veto. The position is same as center level also. Same provision is with President. Now in case of money bill can be introduced only in Legislative Assembly. Same is the case at Union Legislature. It can be only introduced in Lok Sabha. I hope you remember. Bill is transmitted to the Legislative Council for its consideration. It is passed from Legislative Assembly, sent to the Legislative Council. Now Legislative Council cannot reject or amend money bill, can only make recommendations and must return the bill to the Legislative Assembly within 14 days if they have some suggestions. The Legislative Council does not return to the Legislative Assembly within 14 days. If such thing happen, then the bill is deemed to have been passed. It means in case of money bill, the maximum period for which Legislative Council can hold this bill is 14 days only. In case of ordinary bill, it was 3 months plus 1 means 4 months. Finally, when a money bill is presented to the Governor, he may either give his assent, withhold his assent or reserve. The bill is for presidential assent cannot return the bill for reconsideration of the state legislature. I told you in this comparison also that money bill cannot be returned because it's a wastage of time, right? And money bill means it is possible that government is raising money bill because there is some essential, means some urgent matter is there. It may be possible. Expenditure of government is dependent on it, right? Normally the governor gives assent to a money bill as it is introduced in state legislature because it is introduced with prior permission of governor. Same is case of state as in case of center, right? In center, money bill can be introduced in Lok Sabha only on the prior recommendation of president. Now attempt this question. Money bill can be introduced by any member or minister in legislative assembly. Do you think it is true? No, it is false. How can any member introduce? Right? It's a government bill. Ministers introduce. The Legislative Council has restricted powers with regard to money bill, right? Money bill is as it is introduced in the state legislature with his prior permission of the governor, right? President can return the bill to the state legislature for reconsideration, but governor can't. Means it is saying that president can return what? Money bill. No, it is not possible. As I told you, when a money bill is reserved for the consideration of the president may either give his assent to the bill or withhold his assent to the bill, but cannot return. As I told you, it's a wastage of time. That should not happen in case of money bill. Now, position of legislative council. So there are two cases here. The areas where legislative council is having equal say as legislative assembly, and then second case is unequal. Okay, one question can be made from here. Okay, introduction and passage of the ordinary bill. So in case of ordinary bill, it can be introduced in either house, means legislative assembly or legislative council. However, in case of disagreement between two houses, the will of the assembly prevails over the council. Will of the assembly prevails. As I told you, there is no case of joint sitting there. Approval of ordinances issued by governor, means once governor issues ordinance under article 213, when house is reconstituted, then it must be passed from both the houses. Selection of ministers including chief minister, means if someone has to be appointed as minister, then that person can be a member of either house. Like in case of Yogi Adityanath, he was member of legislative council. Consideration of reports of the constitutional bodies like State Finance Commission, State Public Service Commission, Comptroller Auditor General of India, yes, CAG's report with respect to state, right? So it can be considered by the both houses. Enlargement of jurisdiction of State Public Service Commission, in this case also, this they have both houses have same say. Now my suggestion to you is, please remember these 2 points, because earlier 3 points were quite obvious. These are the points which generally students actually forget. Okay, unequal. In case of money bill, it can only be introduced in legislative assembly, not legislative council. Final power to decide whether a particular bill is money bill or not, it is with Speaker of Legislative Assembly only. The final power of passing an ordinary bill lies with the assembly. Means legislative council can hold this money bill only for 14 days. Council can only discuss the budget but cannot vote on the demand for grants. Cannot vote, only discuss. Please remember. Council cannot remove the council of minister. Why? No confidence motion can only be passed in legislative assembly. Same in case of Lok Sabha, right? And when an ordinary bill which is originated in council was sent to the assembly, it is rejected by the assembly, the bill ends and becomes dead. Remember it. But in case of Rajya Sabha, this doesn't happen. Why? Because there is a case of joint sitting there, right? If there is a deadlock. But if legislative council proposes a bill and legislative assembly rejects it, then it is dead. It ends. Please remember it. The council does not participate in the election of the president, because in case of election of president, only elected MLAs vote. I hope you remember. Now, privileges of state legislature. Compare with what we discussed in parliament. It has right to publish its report, debate, proceedings, and also the right to prohibit others from publishing the same. Prohibit others from publishing the same. Although after Supreme Court judgment, any truth, means any truth, can be actually presented, or you can say published by the media houses. Okay, truth, but it should be truth. It should not be you can say their opinion which demeans the house. Otherwise, that is going to be considered you can say against privilege of the House. It can exclude strangers from attending the proceedings. It can make rules to regulate own procedures. It can punish members as well as outsiders for breach of privilege. Same. It has right to receive immediate information of the arrest, detention, conviction, imprisonment or release of member. That is collective privilege. Can institute inquiries, order to attendance, witness and send of relevant papers and record if matter is under consideration there. Court are prohibited to inquire the proceedings of the House or its committees. This protection has been given to the House. No person, either a member or outsider, can be arrested. No legal process, civil, criminal, can be served within the premises of the House, okay, without the permission of presiding officer. Individual privilege, same. The MLA or MLCs, they cannot be arrested 14 days before, 14 days after and during the session. The privilege can only be available in case of civil, not in criminal cases or preventive detention cases. Their question can be asked. So this protection is available only in civil cases. For example, case related to tax, family or land dispute, etc. If you have murdered someone and you are thinking, no, for at least 40 days before, 40 days and in between session you are not going to be arrested, then you are mistaken, my friend, if you are MLA. They have freedom of speech in the state legislature. No member is liable to proceedings in any court, whatever they say within the House. They are exempted from any jury service. So jury service has itself ended. Now it is not used, right? There can be a mains question from here. We say that freedom of speech to the in the state legislature. Do you think there is truly a freedom of speech? Because if an MLA of a party speaks her mind and his opinion is against the opinion of majority of its party members, then this can be a basis of disqualifying this particular member. So now this member is becoming a sheep of the herd. This member is not having independent voice. So some people say this is actually against freedom of speech and expression. So how anti-defection law is curbing freedom of speech and expression of these members? How these members are reduced to party members, not true representative of their people. So this can be a question here. Now Council of Minister does not include whom? Parliamentary secretaries, because all three categories are part of COM. I discussed with you in video number 1. Video number 1 of state legislature. Using which of the following can terminate a sitting of the state legislature for an indefinite period? Adjournment sine die. Please remember, we are using word sitting, not session. That is why adjournment sine die. This is a factual question. Madhya Pradesh 7th Amendment Act, part 1 video of state legislature, and within the start I discuss these facts. Article in the Constitution provides for dissolution of a state assembly by the President. Article 56, President rule. Suppose the Legislative Assembly dissolves. Now you have to answer this. And suppose a bill has already been passed by Legislative Assembly and also Legislative Council, but is returned for reconsideration by the Governor. Means the bill has already touched the Honorable Governor. President at time dissolution. Then what will happen to the bill? Tell me, the bill will lapse or not? The bill will not lapse because that bill has already touched the stage of Governor. So I hope now this topic is clearer to you, right? If you have any doubt, you can shoot me a message on my personal Insta, shashank.powerbeam. This PDF is going to be available in this Telegram group, Shashank Tyagi for you. See you in the next video. Till then, keep learning, keep growing.